Hello, everyone. Welcome back to another episode of Tantra's Mantra, where we go behind and beyond the tech news headlines. I'm your host, Prakash Sangam, founder and principal at Tantra Analyst. By now, I'm sure most of you have heard about Apple suing OpenAI for theft of confidential information. This case comes at a very crucial time, when everybody is looking forward to unveiling of interesting new AI personal devices. Supposedly both companies, Apple and OpenAI, are working on them. Actually, OpenAI did tease about it. They didn't give a lot of information, but they had a session wherein Sam Altman and Jony Ive came together, talked about it in abstract terms, and said they're basically excited about it and so on. So this case basically puts a huge hurdle in their plans, productizing this idea they might have. And when you really look at the Apple's complaint, I read through all 40 pages of it. It's really fascinating and interesting. It's a mix of blaming the individuals but trying to put the blame ultimately on the larger company OpenAI, and it also includes the company that it acquired, IO products, founded by Jony Ive, and both the units of OpenAI, the non-profit as well as the for-profit enterprises. So to discuss all the aspect of this case and what's next and so on, I have with me Christie Theone. She is the principal at CTG Advisory. Christie, welcome to the show.
Thank you. Thank you for having me.
And notably, Christie is a lawyer herself, and most recently was with Qualcomm. She was VP of Policy and Legal Communications there, and she has seen many such cases being at Qualcomm, right, Christie?
Yep,
Okay.
definitely.
Yeah, so let's get started with the questions. I would like to divide the discussion into three parts. Of course, there'll be overlaps, but give some structure. The first one is about Apple's complaint itself, how it is structured, and so on. Second, OpenAI's response, which is pretty small and short at this point of time, but what they might be doing and so on. And third, what this means for the industry, the companies, and what are the next steps and so on, right? So let's get started with it. The first question from the first section, the Apple's complaint. As I mentioned, it is a mix of individuals, although centered around individuals, but it also brings in OpenAI and this IO products as defendants, right? So I think Apple is trying to, cast a wider net, although it is directly implicating employees, but they want OpenAI to be, liable for it, so that they really have a bigger fish and in a way kind of put a hurdle in their AI product plans as well. What do you think?
Well, thanks, Prakash. I appreciate the question. I think this case is fascinating, and I think everybody and their mother are going to be watching it because all of some of the most important characters and personalities and innovators serious about it in the AI space. And I think it also comes at a really interesting time for Apple because they're about to embark on a period of transition in terms of leadership.
Of course,
so there are 100 backstories to all of this, I'm sure, and lots going on behind the scenes. And I don't think any of us observing it from the outside are really going to know all of the different motivations until we see more that gets filed in the public domain, and then eventually, if this case goes to trial, imagine that all of it will be laid bare there. But in the short term, it's from reading the complaint, and it's pretty average length at 41 pages.
Yeah.
It does seem like Apple's trying to create a narrative. Definitely put stakes in the ground first. And it had been rumored that OpenAI was maybe getting ready to sue Apple.
Yeah.
So or not, that's true. I don't know, but Apple definitely got there first. And I think has crafted a pretty evenly calibrated, not over the top narrative of of what's happened, and upset about it, and what they're asking a court to do, which is basically get OpenAI to stop doing what Apple alleges that it's doing. So I wasn't surprised to see the breadth of who they sued. I think it makes sense that they include everybody who they think might need to be involved in the case, both from liability perspective and also just so they can do discovery and get all of the information that they think they need to prove their case.
Of course, yeah. And is there an advantage for OpenAI to differentiate between the individuals and the company, so that there is some language on how systematically it was set up, but all of that is kind of centered on this one person Tang Tan, not necessarily, I don't think Apple has made a strong case of it was a systematic company-wide approach. It's mostly, this one individual who carried a lot of stuff and the other individual who was basically trying to eke more information from the companies, from the employees who are he's trying to hire for OpenAI, right? So is there in OpenAI's interest to bifurcate this case rather than make it one? Can they do it, or?
Be surprised if they were able to do that. I think again, you're talking about, even if the allegations are primarily focused on a couple of employees, they're still employees of the company. So generally speaking, the company is going to bear responsibility along with the employees unless there's some exception to that. But
Okay.
Stepping back a bit, what struck me is that it looks like Apple's really trying to taint everything that OpenAI is doing with I/O. So by focusing on the facts around a couple of employees, they really seem to be making the argument that everything that the company is working on is tainted by this behavior, and that it trickles down into all of the engineers and other employees who've come over from Apple. According to the complaint, it's more than 400 at this point.
Yeah.
So I think that's the broader effort here, is to sort of show that in Apple's view, this behavior has infected everything going on over there.
Yeah, and they did mention a few times the foreign employees have joined them, but it's I don't think it stands in the code as such, right? It is more of anti-compete clause and so on. So I think it's, as you said, more narrative setting, but that's not very substantive, is it?
I mean, we'll find out. We'll see. This is really early days, so I think a lot remains to be seen.
Yeah.
Interestingly, and sort of as a side note, we're seeing a real uptick in the number of trade secret cases, and I think the non-competes are not enforceable in California.
Yeah.
And we saw the FTC try to do away with them nationally. So companies, in some ways, are left with fewer tools to try and enforce some like this. So we're definitely seeing more trade secret cases being brought. And I think you also have a dynamic where we're on the cusp of this huge revolution in technology. And every time we see one of these new technology transformations, you see a lot of movement, you see a lot of conflict, you see a lot of disruption, and a lot of litigation. So all of this fits.
It's a lot of things are at stake here, right? So
Of course.
and drilling down into the actual complaints themselves, I think there are some very substantial and I would say easily provable allegations. For example, Mr. Chang Lu basically not returning Apple's laptop and illegally accessing, using a loophole and accessing their confidential information, accessing Apple network even after his employment ended. Those are easy to prove, right? And those seem to be straightforward, right? And they can be attributed to individual, not necessarily saying company enforced him to do it, right? What do you think?
Well, and at this stage of the game, we are talking about allegations. So these are allegations that Apple is making towards OpenAI and others. And of course, OpenAI will have a chance to respond. And there will be lots of litigation and discovery, and then, like I said, ultimately a trial maybe. So it's very early days. But whether or not the allegations are easy to prove, I don't think any of us has any way of knowing at this point. I mean, the way that they've drafted the complaint, it sounds pretty matter of fact. And as I said at the top of the program, to me, it doesn't strike me as particularly over the top or inflammatory in terms of the language and the way that they've positioned this whole thing. So I think that was I'm speculating here, but I think that was part of the goal, was to make it all sound like it's a pretty open and shut case. But the litigation is complicated. Litigation between big companies is incredibly complicated, and a lot can happen. My guess is there's going to be a ton of discovery, lots of emails and documents and other things will get looked at. There's obviously a lot going on between these two companies. So I think it is way, way, way too early to predict who's got the easier case, what's easy to prove, what's the slam dunk. I know enough to know that nothing is ever a slam dunk. A few things are, maybe some cases are, but I would say those are the exception and not the rule. But obviously they've done the math here. They've weighed the pros and cons, and they decided to proceed with a pretty big case. So I think it's going to be very interesting to watch.
Yeah, indeed. And also just my comment, I mean, I'm not a lawyer for sure. So the person, if you look at the list of complaints, majority of for this Mr. Chang Lu, and he is not even a senior executive. I think listed as electrical engineer or hardware engineer or something like that. And those are very substantive. The allegations against Mr. Tang Tan are more suggestive rather than, substantive in my view. Again, I'm not a lawyer, but yeah, these never seem to be what they actually appear from the top, right? Okay, so and also it's interesting that IO Products, the company is mentioned, but Jony Ive's name never comes up here. Maybe I'm thinking maybe because they didn't want to tarnish his legacy with Apple. I mean, most of the iconic products that Apple has were designed by him. So that is an interesting exclusion in my view.
It is interesting,
Yeah.
and I think it adds to the interest in the backstory behind this
Yeah.
case. And
Mhm.
and we litigated with Apple. There was lots of interest in the case because it was Apple. Anytime Apple's involved, you're going to have a big spotlight on the case. And I think because it's such a storied company and obviously incredible products since they introduced the iPhone back in 2007,
Yeah.
everybody's going to want to know what's really going on behind the scenes. I think as it relates to Jony Ive. I think it's interesting that they didn't mention him. Maybe that's out of respect. We're not going to know for a long time. We may never know, but
Yeah.
it does seem like they're really focusing on the products, and it feels like it's again this sort of tainted atmosphere where you've got these employees engaging in what Apple says is illegal conduct, and that's sort of tainting everything that the companies are doing and what they're doing with IO.
Yeah,
So we'll
yeah,
see.
basically using these few instances and painting the broad brush of the innovation on the device side from the company,
Right.
saying it's all stolen or something like that. Okay, cool. So and then OpenAI reply. I mean, it was a political reply, and it's a public PR response. Right, it's very short. Just stating the obvious. Right. You've been in this situation before. The press statement that OpenAI came up with, that's pretty standard, right? Is that what you would have done, or would you do anything different?
This stage of the game, it's exactly what I would have done. I think
Okay.
they got the complaint on a Friday, which is I'll tell you is never any fun,
Yeah,
and I'm sure it ruined more than a handful of people's weekends. But
absolutely.
from the complaint, there's a reference to a February letter that Apple sent to OpenAI, and they didn't get a response to that letter. So that's that maybe this has been brewing for a while. It takes a long time to pull these things together.
Yeah.
So, who knows whether or not OpenAI was surprised by this. But in any event, it came on a Friday and there was a ton of news coverage. The company's got to react really quickly to at least get something out.
Yeah.
And, it was interesting in this case, they just posted a very brief comment on X. But, as a communications expert, I would have advised something very similar. They haven't answered the complaint yet or filed any kind of responsive pleading. So they'll have an opportunity down the road to really flesh out their defense and their version of the facts. And I always think it's a good idea to kind of keep your powder dry, be succinct, be clear, but be very brief before you've actually started to engage in that formal litigation process. So I wasn't surprised by it. I think what's also interesting to keep your eye on is the back and forth between Elon Musk and Sam Altman, which has been happening this weekend. So I think you're going to see all these sort of parallel venues, if you will, where some of these issues get debated and discussed by the CEOs or some of the CEOs who are watching from the sidelines themselves.
Yeah.
So that makes it an even more interesting case to follow because I, in my experience, most CEOs are not out there commenting on X or some other platform, sort of X party, if you will, to the litigation itself.
Yeah.
So this is going to be an interesting one.
Yeah, I mean, Elon has had the fire as well, right?
Yeah.
Yeah.
So,
Okay.
yeah. So
Yeah.
this is it in some ways it gives you kind of a backstage pass almost, but they want that they know obviously this is a very public discussion. So, but in terms of watching it in the context of the litigation, it sort of ups the interest level, I would say.
Indeed. And of course, it's very early. So, I mean, in the next step would be, I would expect, obviously, they'll have to file a reply. Probably they'll get an extension or something, apply for an extension. 21 days is too
Usually
short
30
a duration.
is the normal period of time. Lots of
Yeah.
companies get an extension out to
Yeah.
60 days, whatever it is they need. Sometimes they
Correct.
can reach an agreement with the other side to do that, or they'll go to the court and ask for more time. So
Yeah.
I think that'll be the next big milestone in this case is to see what OpenAI files. Did they just go ahead and answer the complaint? Did they try to get it thrown out in some way? Did they try to narrow it? I think it's also going to be interesting to see if they file, in addition to responding to this lawsuit, a lawsuit of their own.
Yeah,
where
counter lawsuit.
they
Yeah.
back,
Yeah.
maybe make some allegations of their own against Apple for breach of contract, which is what Bloomberg had reported some time ago, that there was a potential dispute brewing between the companies with regard to the integration of OpenAI's products into
Yeah.
products. So I think that's something to keep an eye out for too.
And that is not out of the ordinary, right? I mean, such situations, companies basically to have leverage, they countersue and ultimately it'll be combined into one
Right.
big case if it moves forward, right? So,
Yeah,
okay.
there's lots of activity at the beginning of the case where both sides are taking those initial shots across the bow.
Yeah.
And then the pleadings will eventually get sort of firmed up and locked and loaded, and then a long period of discovery will ensue. And I think people will be clamoring for information about this case, but it could be that a lot of it is confidential. I mean, it's a trade secrets case. So by definition, talking about very sensitive information, the crown jewels at Apple.
Correct.
So,
Yeah.
and a company that is notoriously secretive for good reason.
Yeah.
So I don't know that we're going to get a glimpse of all of it, but keep your eye on the docket, because there will be disputes no matter what. I can almost guarantee.
Yeah.
So
Of course. Yeah.
who has to produce what and who gets deposed and all of that. So keep your eye on the docket. Good reporters do that anyway. I know the analyst community does that a good job of that too. So keep your eye on the docket, and you can start to see where those fights start to erupt.
Indeed. See, we brought it up. So the discount is going to be very interesting in this case. I tweeted about it as well. There is so much at stake, of course, and there's so much of work that nobody wants the outside world know about it, right? On both sides, because the new devices, people are they're still innovating on them. Nobody knows what those are and so on. So how you think that will play out? There'll be a lot of the discovery itself will be very adversarial in my view, right? One side asking to get more information, other side asking to narrow it down to the case as narrow as possible and so on. And I'm sure you dealt with many of such cases. So how does discovery look like in this?
Well,
Would any of the ultimately when they file, they can have a lot of redactions and so on, but the public will get some glimpse, right? If it comes to that once they file.
Maybe we tend to get glimpses when there are disputes, and then the parties have to go to court and they file papers and they claim we asked for this and we only got that and we're really entitled to this, just as an example. So we may get glimpses of it as those disputes erupt or as different motions get filed. But my guess is by and large, this will mostly be behind the scenes, confidential. And in some cases, even the in-house attorneys don't get to see everything. So a lot of stuff gets I'm not an expert in all of this, but I know a lot of evidence ends up being for the attorney's eyes only. And you really don't get to see those kinds of things until trial. So when courts really err on the side of making things public, there's a public interest in having visibility into a case. So I think we're going to have to wait and see, but I expect discovery will be very broad. I mean, the complaint itself references some facts, alleged facts, and then goes on to say discovery will in their opinion reveal more. So I think we just have to wait. Again, we have to wait and see. I think, again, this is a generalization, but the lawyers need to plead enough facts that they can clear the sort of initial hurdles to get the case into court. Because otherwise, the side will come back and say, you guys don't have a case here. You haven't even pled enough facts to get this thing out of the gate. So I think from my read of it, it looks like Apple actually wanted to be very specific in this instance, plead probably a lot of what they have, and like I said, really put stakes in the ground around their narrative. I mean, they quote different messages and back and forth between employees, and so I think again it's going to be really interesting to see what OpenAI comes back with. I wouldn't expect them to start disputing word for word at this stage of the game. Probably much later, but yeah, I think it'll definitely be interesting to see what comes out. What we get to see.
You think the discovery itself is so, it could be so complicated that pushes the companies to settle? I know.
You never know what pushes companies to settle. And I think, again, it's early days. So it's going to depend on how discovery goes. It's going to depend on 100 different factors. And each company is going to come to this litigation, obviously, with a different set of motivations and priorities. So I think, this comes, as I mentioned, at a time of transition for Apple. It also comes at a really critical time for OpenAI as they're
Of
wanting
course.
to IPO.
Yeah.
They've been teasing this new product, the collaboration with Jony Ive, which everybody I think is
Looking
dying to
forward
see
to
what
it.
that ends up being.
Yeah.
And so my guess is it'll be a series of business calculations and as well as which side thinks the litigation is going better for them. So it's in my experience, it's never just one thing. When it comes to companies this big who operate on a global scale, and Apple obviously is one of the most valuable companies in the world, um, it's a multitude of things. So
Yeah. Yeah, indeed. And it is as it stands today, if there is a countersue by OpenAI and what the allegations are, we don't know, or we don't even know that that will be the case. But I think OpenAI is lot to lose at this point of time, right? I mean, Apple has time on its hand, whereas OpenAI is the one being obstructed in their product plans as such, right? So I think they would be inclined and motivated to end this sooner and the confusion and the uncertainty than Apple. Don't you think?
I think the short answer is we don't know, and it's way too early to say. I think it goes without saying Apple is obviously a big established company
Yeah,
with lots and lots and lots of resources. And as we've mentioned, OpenAI wants to go public.
yeah,
The financial reporting is that they spend a lot of money. They're spending a lot of money, which makes sense at this stage of their development.
yeah,
So, but again, I think there are a lot of things that need to happen before probably either side makes a decision in this regard. I mean, Apple seems to be very clear on what it is they're trying to achieve. I think we need to
hmm
wait and see what OpenAI comes back with. But you're right. I mean, at some point, OpenAI is in a different position. They're going to need to think about, all right, what are our ultimate objectives, and is this lawsuit something we need to clear the decks of, or does it make sense to go the distance? And most cases settle. So I think if it does settle, that won't be surprising. I think the
yeah,
time of the settlement will be something to keep an eye out on. But I think if it does, depending on what the terms of that settlement are, because in this case, Apple's really asking the court to enjoin OpenAI from doing some things. So what does that mean? Does it mean it can't make the products that are in development right now? Does it mean they have to stop working on those products? Does it mean we have no idea? I mean, it's pure speculation, I think, for those of us on the outside at this point to try and assess what we're really talking about when we even suggest what a settlement might look like. So
yeah.
I know I can give you this answer, but it's all sort of wait and see at this point.
Yeah, yeah. So I mean, logically thinking, it'll take at least 1.5, 2 years if it goes to
Probably. That's pretty
right
standard.
to full phases of it and goes to trial and jury trial and dissonance, all that. So which means during that time, OpenAI's product plans will be on hold, which is big obstacle for them. And if you look at the remedies that Apple is asking and joining in, which is basically stopping all the work OpenAI is doing, which is again major hurdle for them. And also they said the only way they see is injunction against OpenAI. That I think is a major ask. I mean, we talked about this before. Injunction is not that easy to come by these days, right? So,
And
and there
injunction
is no
is hard.
monetary compensation that Apple is asked for. I think they mentioned it, but no numbers and such, right?
It is hard. It's hard. And it'll be interesting to see if Apple asks for some preliminary rulings early in the case. If it's that
Mm-hmm.
dire, they need OpenAI to stop doing what they're doing before this case even
Right.
gets to a
Yeah.
trial.
Yeah.
So, but I think that's going to be interesting to watch for too. But yeah, I mean, it's as much as the complaint reads sort of matter of fact. Here are the things that happened, and they shouldn't have happened, and the court should ask them to stop doing these things. It's never that cut and dried. I mean, it's again, we talked about lots of discovery will take place.
Mm-hmm.
There's lots going on behind the scenes and in the public arena as this thing gets litigated. So, I think we have to wait and see. But yeah, I think that 2 years is probably a reasonable time frame. Could be a little bit longer than that. The parties don't have a trial date yet. They'll get one at some point when they meet with the judge. The judge will put down a whole schedule. So we'll have a good idea then about what's going to happen when.
Yeah.
So.
And one last question. So with the case ongoing as it stands now, do OpenAI stop working on what they're working on, or they can keep working on unless there is a direction by the court and so on as the case goes on, or they have to stop working now?
Well, the judge hasn't ordered anything yet.
Okay.
So at least in the context of this litigation, OpenAI can keep, they're probably going to continue to do whatever it is they're doing.
Yeah.
So I think until a judge orders them to stop doing something, there's really nothing more that Apple can do to get them to stop. I mean, they've got to go through this court process. This is the process. It's time consuming. It's expensive. It's potentially risky reputationally for both companies. But this is not Apple's first rodeo, not by a long shot. So they've got excellent attorneys. They just brought a group over from another firm to a firm that they've worked with for years. So about lawyers at the very top of their game who, at least based on the complaint, have thought this all the way through, I'm sure. So I think, we just have to wait and see. But
one more. I said the previous one was the last question, but one more based on discussion. So would it be reasonable to expect that the first salvo from Apple would be stopping the work that OpenAI is doing, and the first salvo from OpenAI would be to dismiss the case based on lack of merit and such? Would those be reasonable?
They may try. You may see that.
Okay.
AI, they may try to argue that the case doesn't have any merit just on its face.
Okay.
I think they have an extremely hard time doing that, and my guess is they probably won't go that route. But again, that's speculation on my part. I think again, you're talking about really experienced lawyers who do this at the very, very, very top level.
Yeah.
So I think, they know what they're doing in terms of writing that initial complaint such that it's very difficult to just get it sort of dismissed.
Okay.
So I think this is going to be pending for some time.
Okay.
They have to respond. And that I think we'll be watching to see if they file their own lawsuit back, and that'll all probably be consolidated into one big lawsuit. With all the is connected and witnesses and all of that. So I think that's probably the way it's going to go.
Cool. That was a great discussion, Christie. And this is, as you said, a fascinating case with a lot of impact on the overall industry as such. And thanks again for your insights. It's only the beginning. We'll keep following up and see what comes up and what unfolds. And which means that I'll bring you on to the show
anytime.
Very quickly.
So anytime, I'm happy to, and I'll be keeping an eye on it for you. So happy to come back anytime and give you my thoughts on where it all stands and how the public is perceiving it, and what I can sort of my best guess about what happens next.
Cool. So now tell us about your venture, CTG Advisory.
So I after 18 years, I left Qualcomm in April and loved my experience there. As you mentioned at the beginning of the program, I managed litigation and policy communications there. So I was embedded with our legal team for many years, helping do communications around Qualcomm's litigation matters. So I'm out on my own now and getting a chance to take that experience to advise others. So watching this case has been really interesting. It's kind of fun to be able to comment on things that I couldn't before. So yeah, that's what I'm doing.
Excellent. So I highly recommend Christie. She's the best in the business. Definitely reach out to her if you need any such services. So Christie, again, thank you very much for coming over to Tantra's Mantra.
Thanks, Prakash. Great to see you.
So folks, that's all we have for now. Hope you found this discussion informative and useful. If so, please hit like and subscribe to the podcast on whatever platform you're listening this on. I'll be back soon with another episode, putting light on another interesting tech subject. Bye-bye for now.